On behalf of Space Education and Research Foundation and on my personal behalf, I am very happy to welcome Professor Arup Das Gupta and all participants from different countries to this webinar on space debris. In this series of space debris, we have had already 4 talks, and today is the last and the 5th talk. This is on space debris and space laws, and a very important and upcoming topic for discussion. This talk is going to be presented to you by Professor Arup Das Gupta. Before I hand over the mic to Professor Arup Das Gupta, I will briefly introduce him to you. Professor Das Gupta had a very excellent academic career. He did his master's degree in engineering, electrical and communication engineering from Indian Institute of Science, Bangalore in 1970. He was adjunct faculty in DAIICT and SEPT. He has more than 48 years of experience in satellite communication, remote sensing and GIS. In 2005, he retired as Deputy Director, SATCAM and IT Applications Area of Space Application Center, a unit of ISRO at Ahmedabad. And after that, he served for from 2005 to 2009 as Distinguished Professor at BISAT, and later served as an independent director of Skene Point Geomatics from 2009 to 2014. He has made very significant contributions in the field of remote sensing and geoinformatics. For his excellent contributions, he has received 2 awards, Excellence Awards, one in 2005 from Indian Society of Remote Sensing, and second one in 2016 from Indian Society of Geomatics. He is also recipient of Lifetime Achievements Award from 2 organizations. One, the Geospatial Technologies in 2009 and Astronautical Society of India in the year 2000. He is a senior member of IEEE, Fellow of IETE and ISG, Life Member of INCA and ISRS. His current interests are in space policy, convergence for space and information technologies for sustainable development of planet Earth. He is currently managing editor of Geospatial World magazine. With these few words, now I invite Professor Arup Das Gupta to join the room, and I myself will leave the room and listen to his talk. Professor Arup Das Gupta, please.
Thank you, Dr. Watts, for that nice introduction, and a very good morning, good evening, good night to all of the people who are attending this particular lecture. My talk is going to be on space debris and in the manner in which space law is attempting to solve this problem through the legal means. Now, if we go on to the series which started some 4 days ago, we have learned a lot about how space debris is created, both naturally as well as through human activities. Then we have learned how this debris can be tracked and detected, and then how it can be avoided and mitigated. What we will now look at in this lecture is what are the legal issues relating to space debris mitigation and control. So with this very brief introduction, I will get on to the topic. Now, previous speakers have also spoken about the Kessler Syndrome, so I'm not going to spend too much time on this. But what I really want to do is concentrate on the last bullet, which is what are the legal implications in the event of such a meltdown happens, and more particularly, how can we prevent this meltdown from happening? So, if you look back in history, you will find that we first attempt at getting an object into space by human beings was by the USSR in 1957, and this satellite was called Sputnik 1, and it created a huge wave in the world. And then between 1957 and 1967, that decade, one saw a huge amount of activity in space, 185 other launches, many including animals say being sent into space. Russia sent a dog named Laika. Then human beings started going there. And so what happened was that this raised a lot of concern amongst the people in various countries, and this matter started getting discussed in the United Nations. And in 1967, exactly 10 years after the first space object was hurled into space, the United Nations adopted a law, and that law has become the basis of all international space law, and that includes the issue of debris. Now that law is a very big name. It's called the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. That's pretty comprehensive, but to keep things short, we'll just call it as the Outer Space Treaty, and that's what everybody else also calls it. So, if you look at the activities of the UN in terms of space, in terms of legal issues relating to space, you will find that apart from the Outer Space Treaty, which has been in force since 1967, there are four more. One is called the Rescue Agreement, or the proper title being Agreement on the Rescue of Astronauts and Return of Astronauts, and the Return of Objects Launched into Outer Space. This has been in force since 1968. Then the Liability Convention, or the Convention on International Liability for Damages Caused by Space Objects. This came into force from 1972. Registration Convention, or Convention on Registration of Objects Launched into Outer Space. This came into force in 1976. And then with all the activities on the Moon came the Moon Agreement, or Agreement Governing Activities of States on the Moon and other celestial bodies, which came into force from 1984. Now I have highlighted in yellow some of these treaties or parts of the treaties which are relevant to the point what we are discussing, which is basically space debris. Let's spend a little time on the Outer Space Treaty, because this is the mother of all the treaties, and it says, I mean, put it in very simple language here because I don't want to use all the wherefores and therefores and all that. So one is that the exploration of the outer space shall be carried out for the benefit of all mankind, and in fact outer space shall be free for exploration and use by all states. Now here the term states means various countries, right? So you see, what basically the United Nations want to say was that outer space is a property of all mankind, right? So nobody can say this part of space is mine and that part of space is yours. It's for everybody, right? So therefore it is not able for national appropriation. You cannot claim sovereignty over it in any means, whether by occupation or by any other means, right? And states shall not place nuclear weapons or other weapons of mass destruction in orbit or on celestial bodies, or station them in outer space in any other manner. Now this is a very crucial point, because if you look at the anti-satellite tests which have been carried out by the US and the USSR and China, and now finally by India, this is the crucial part of the treaty. And you may think that we have violated the treaty, but we have not, because the key is not place, not station, and weapons of mass destruction, right? So what has been done is that you have sent missiles with with warheads which are not explosive type, but which can kill by means of what is called as the kinetic weapons. Okay, but we will cover this in a little more detail. Let us now go on to the continue with the treaty clauses. So it says the moon and other celestial bodies shall be used exclusively for peaceful purposes. Astronauts shall be regarded as the envoys of mankind. Okay, and states shall be responsible for national space activities, whether carried out by the governmental or non-governmental entities. Which means even if there is a private operator who is sending things into space, and there are many today, but who is responsible? Not just the private operator, but the country in which the private operator is registered. State shall be liable for damages caused by the space objects, and this comes later in the Liabilities Convention. State shall avoid a harmful contamination of space and celestial bodies. Again, note the word contamination. This has certain legal implications. So let's look at the Liability Convention, because that is one of the most important points if you are looking at space debris. And it says, and this is taken from the Article 7 of the Outer Space Treaty, and it says that Liability Convention provides that a launching state shall be absolutely liable to pay compensation for damage caused by the space objects on the surface of the Earth or to aircraft, and liable for damage due to its faults in space. And the convention also provides various procedures for settlement of the claims for damages. We will again discuss this later. But note how the differentiation has been done: on ground, in air, and in space. Now there is the registration convention, and this is a very interesting convention because it is now mandatory for anybody launching anything into space to inform the United Nations, who maintains a register of what has been launched, where, and for what purpose. And this is an open register, anybody can access it. So therefore the idea is that tomorrow if something happens and a person and say a particular state affected, let's say a piece of debris has come and landed on that state, they can go to the register and find out who was the originator of that particular object. So this is something that's very important. Then there is the rescue agreement. Again, this is mainly deals with the astronauts and the return of astronauts, but it also deals with the recovery of space objects and the return to Earth outside the territory of the launching state. Now, I think Sivaraman gave a very excellent example with a photograph of a fuel tank of a Delta rocket which has landed in Saudi Arabia. Now, who launched the Delta rocket? USA. Where did it land? In Saudi Arabia. By this agreement, Saudi Arabia is bound to return that object to the United States, no questions asked. Okay, so therefore this part of the rescue agreement deals with space debris which can make it down to the Earth, and I mean if it damages something, then there are liabilities which are involved, which we'll talk about later. Even if it doesn't damage anything, it has to be returned to the launching state. Now, apart from the treaties, there are certain principles. Now, what are these principles? These are, non-binding. Treaties are binding. Once you have signed a treaty, is binding on you. But non-binding principles are suggestions. Okay, this is the way you should do things, but it's not binding. They will become binding if they get formalized as treaties, but till now, nothing has been formalized. One is the basic legal principles which are adopted in 1963 before the Outer Space Treaty, and now they have become articles in the Outer Space Treaty. So this is binding. Broadcasting principles in operation since 1982. Again, it basically talks about broadcasting from space, one country broadcasting to another country. All these sort of things are handled over there, but there is nothing binding on it. Similarly, remote sensing principles, which came into force from 1986, again, is a fairly general document which says what are the best practices which can be followed for remote sensing. Well, since I have been in the field, I can tell you that these principles are more observed in the breach rather than in the following. Then there's the nuclear power sources principle, which is in 1992. This came out because there was a Russian spacecraft which was using a reactor as its power source, which landed in Canada, and that set off this particular discussion. Still, there is no legal issue involved, but this definitely again has a relationship to the debris problem what we talked about. Then there's something called the Benefits Declaration that came in force in 1996. We need not worry about that because that's nothing to do with what we have under discussion. Now, let's look at specifically from the point of view of debris. What are the relevant articles? And these relevant articles, as I said, first came the legal principles and then they got converted into the articles in the treaty which are binding to those who have signed that treaty, right? So there are three clauses in the legal principles, 6, 7 and 8, which we will discuss. These are corresponding articles in the outer space treaty are 9, 8 and 7. Now I don't know why the order got reversed, but that's the way it is. But the articles are very verbose, so we are not going to go through those articles. My slides will go into hundreds. So better I will discuss the legal principles where the principle is explained and the wherefore and all that business can be taken care of by legal experts. So the clause 6, first is that it says that in the exploration and use of outer space, the states should be guided by the principle of cooperation and mutual assistance. And all these activities should be conducted with due regard to the corresponding interests of other states. What does it mean in simple words is, I'm going to do something in space, I should do it in such a manner that I do not disturb others, okay, whatever they are trying to do. So if you launch a satellite and the satellite goes and hits another satellite, well, you violated that particular principle and that particular clause. If a state has reason to believe that an outer space activity or experiment planned by it or its nationals would cause potentially harmful interference with activities of other states in the peaceful exploration and use of outer space, it shall undertake appropriate international consultation before proceeding with any such activity or experiment. And this is now very, very important from the point of view of the ASAT test. Because the ASAT test is definitely planned to go and bust a satellite, create debris. Okay. Now, this particular clause says that if you want to do such a thing, you need to discuss with others that this is going to be done and it may create certain problems for you. And the third bullet, if you see, is that any other state which feels that that state is going to create a problem is at test, then that state can demand a consultation. And both these parts of the clause 6 are observed more in their non-observance than in their actual observance. USA, Russia is the biggest creator of debris in the world. Next comes the US, then China, and now India itself has very proudly added itself to that exclusive club. Okay, so what this basically says is that you cannot do anything in space which will harm or potentially create a problem for any other country. And this is again a very important point, and this links to the liabilities. So when we come to the legal principles, clause number 7, the state on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object at any personnel thereon while in outer space. This has a very big implication which we will discuss later. What it basically says is that any country which has launched an object and it is entered in the registry, it is the property of that state and it will be controlled only by that state and nobody else. And the second bullet, ownership of objects launched into outer space and of their component parts is not affected by their passage through outer space or by the return to Earth. So again, what it says is that the person, the country which launches the object is the owner of the object, it remains of the owner of the object, even if, therefore, if it has created a debris, that debris is technically owned by that country. Okay, and not only that, but if the debris comes down on the Earth, it's owned by that country again, right? And remember the earlier article where we talked of the return of objects, it ties up with this. Such objects or component parts found beyond the limits of the state of registry shall be returned to that state, which shall also furnish identifying data upon request for private return. So supposing a piece of debris from space has hit your house, okay, you have to return, that means your government will have to return it to the originating country, and the originating country has to furnish data which says that, yeah, this is debris part belongs to me, okay. So you see the implication of this. So if my house is now hit by a debris, let's say coming from a Russian satellite, I'm going to ask my government to ask Russia to compensate me and repair my damage. That's the basic implication, simply put. Clause 8. Here it says each state which launches or procures the launching of an object into outer space, and each state from whose territory or facility an object is launched is internationally liable for damage to a foreign state or to its natural or jurisdictional person by such objects or its component parts on the earth or in outer space. Okay, so if a country has launched a satellite or launched anything, and that a country is responsible internationally for any damage that that particular object may cause to any other country or any other person or any other object. In fact, even a component part, if it returns to Earth, as you saw the example of the fuel tank, you know, or if it's in the airspace, if it hits another aircraft, let us say, or if it's in outer space itself. Remember the example which I think Shivaraman talked about, the two satellites, the Russian Cosmos and the Inmarsat satellite, which I think it was Iridium satellite, which collided. Okay, all these, the liability is of the country which has launched that satellite or object. Okay, so this is very clear as far as the liability is concerned. Now, the big issue that comes when we talk legal is what is space debris. You have seen the definition of debris as far as the scientific and technology part of it is concerned from the previous lectures, but this interpretation is always open once you get into the legal domain. So in the legal domain, again, there is no accepted, there is no legal definition, but there is an accepted definition which is now legally acceptable, and that is there is a committee called Space Debris Mitigation Committee, and this has issued some guidelines, and the guidelines say space debris is defined as all man-made objects including fragments and elements thereof in Earth orbit or re-entering the atmosphere that are non-functional. That's very important. It has to be non-functional. And this definition is non-binding, as I said, but most nations now have adopted this definition of space debris, and they put this as a part of the domestic law. And therefore, this definition more or less reflects what is currently acceptable, and it's only a matter of time before it becomes a legal definition. Now, there are ambiguities in the treaty, outer space treaty, and these naturally arise because remember the outer space treaty was written in 1967, and then so many years have passed beyond that. So, if you look at the Article 9, which is based on the legal principle 6, state parties to the outer space treaty shall conduct all activities in outer space with due regard to corresponding interests of all other state parties to the treaty. I mean, this is that same thing what we discussed earlier. So, with due regard. Now, this can be legally interpreted that all state parties who are signatories of the outer space treaty are obliged to avoid the creation of or even reduce or even remove space debris to allow states to participate in the exploration and use of outer space with minimum risk from debris. Okay, so now this particular Article 9 can be interpreted in this way that any state party has to not only avoid the creation of debris, it has to reduce the debris, in fact even remove the debris. Okay, this is an impossible interpretation of that Article 9 because it's been written in fairly simple terms, so therefore one can interpret it in many ways. Then there is this term called contamination, right? In Article 9 again, it says that avoid their harmful contamination. What is contamination? Can you call space debris as contamination? That's a big question, because contamination normally is associated with things like, biological or radioactive contamination, and perhaps what the UN meant at that time being going up in space, and there was a lot of talk of atomic warheads and so forth. So they thought that this is something that should be brought in. And also remember this particular case of the Russian satellite with the nuclear power which crashed into Canada. That there was this whole issue of contamination raised at that point of time. I remember a lot of discussion in UN at that time. So can we call space debris contamination? It's point to be noted. Then consultation. Okay, so international consultation process is required, and if a state believes that an activity planned by it or its nationals would cause potentially harmful interference to the activities of another state, it shall undertake consultations before proceeding. Okay, nobody does it. A state party may also request consultation if it believes that an actively planned by another would cause it potentially harmful interference. It's called whistling in the wind. Okay. When we did the ASAT test, did anybody complain or anybody ask India for a consultation? It happened. And it's difficult to describe the existence or creation of space debris as a future planned activity. It's also a point, right? So when we launched that particular satellite on behalf of DRDO, we never turning into space debris was never one of the objectives, right? At least written down. I'm sure in the registry in the UN that would have been not written down that on such and such day or period is going to turn into space debris. So nobody plans for space debris except in the ASAT test. But in other cases, debris just happens. Like for example, when the two satellites collided, they created debris, not intentional. So apart from ASAT test, there is no other activity which is planned to create debris. Also, this particular consultation provision has one flaw, and that is it doesn't address what to do with the stuff which is already up there. I mean, okay, I can. The future, I'm going to do this. I'm going to reduce the space debris, etc., etc. But already, whatever has been created, what are you going to do with that? There is nothing in this consultation process which addresses that issue. Okay, liability. The Article 7, Legal Principles Clause 8 is elaborated in the Liability Convention of 1972, and this sets up a liability regime according to which launching states are liable for damage caused by debris generated by private entities for which such states are responsible. Okay, and only states which are signatories of the Liability Convention can file claims. So if there is a country which is not a signatory to the Liability Convention but has been some of its assets have been damaged by let's say debris coming down on the earth, you still can't find a claim because you are not a signatory of the Liability Convention. So now the liability, let's talk a little bit more about the liability, right? It has twofold, right? First is if the damage is caused on the surface of the earth or to an aircraft in flight. Now this is a fairly simple case because you can prove the causality of damage, and that is sufficient regardless of proving that a fault. That means you don't have to prove that there is a fault on the satellite or on the object which was launched because of which it has come down and it has hit my house or it has damaged an aircraft. Okay, you don't have to prove it. So long as that object is identified as coming from a particular state, that state is liable for the damage that has happened on the ground or in the air. But when it comes to a damage which occurs to another space asset, there the problem is that the affected state has now to prove that the launching state is responsible. How do you do that? Okay. Now, in the case of the Soviet and the Inmarsat satellite crash, okay, how do you prove that the Soviets were in error or that the Inmarsat was in error? How do you prove that? Worse still, how do you prove that? I mean, we have seen a lot of pictures of damage happening to various satellites and the space shuttle and so forth. Okay, those are not calamitous damages, but still there were damages. Now, how would you prove that that particular damage happened because of a debris coming from a particular satellite, or a particular failed satellite, or a particular failed launch? How do you prove that? And this is where the problem comes, because that proof, the onus of the proof is on the chap who has been affected, not on the country which has created the debris. Okay, so it's very great. Somebody says, look, you have your satellite, for example, the International Space Station, and say, okay, my this particular solar wing has been affected by a debris created by, let us say, India. Prove it. India will simply turn around and say, prove it. And can you prove it? Not possible. Okay. So this is the key issue. Can space debris be identified as generated by a particular state in all cases? Some cases, perhaps, if the debris is big enough, yes, but if the debris is not big enough, 10 centimeter piece of debris, you can track it. Can you tell from where, which satellite or which rocket launch or which other space object it has come from? That's the question. So how do you prove liability? So biggest challenge is to prove that the fault is in the launching state. Now in general, fault liability presumes that a certain standard of care is observed when you're making the satellite, when you're making the launcher, when you're going through the launch operations, and finally when you're putting the satellite into orbit, right? Certain care is supposed to be taken. There are a lot of engineering standards which are being used for that. Take the example of the IRNSS, which did not get into orbit. It was not planned to not go into orbit. What happened was that the nose cone failed to deploy. Why the nose cone failed to deploy was because the pyrocutter did not cut a particular cable which would enable the nose cone to separate. So even though the other pipe was fired, but the nose cone was kind of half open, and you could see the IRNSS moving around inside that. So now all particular responsibilities were taken, all precautions were taken. One pyrocutter didn't work. You can't say that that's the fault of the Indian designers, right? It can happen. Any mechanical or any such object, there are always failures. Okay. So, and the thing like a pyrocutter, you can't test it because you have tested it's over. You have to put a new pyrocutter, right? So therefore, how do you blame another country that because of your poor design or practices or processes, this has happened? So proving a fault requires the claimant state to establish that the owner of the debris that caused the damage did not comply with national or international standards or guidelines for conducting space activities or for debris mitigation. This is a very difficult thing to prove. No country will agree to this, because they do follow standards, they do follow procedures. And if a fault has happened, it has happened. GSAT 6 got lost. It got lost not because of any mistake of the designers or the launcher or whatever. It got lost because there was a failure on board which was not anticipated. What do? You can't go back and say that why didn't you anticipate it? These are kind of issues that are there. So there is a need for standards and guidelines. Now again, although we all follow standard guidelines, all launching states, but there are no mandatory international standards for debris mitigation against which a fault can be assessed, right? So only voluntary and non-binding standards and guidelines are there on space objects and debris mitigation, and these are available from various agencies. One very important agency is the Interagency Space Debris Coordination Committee. It's a voluntary committee in which many countries, mainly the launching countries, have come together, and they have come out with standards. We'll be discussing some of these on on basically how to reduce the debris, how to not create more debris. Then there's the United Nations. Okay, we have been discussing those laws. Then there's the ISO, the International Standards Organization, which also everybody tries to follow, because we follow the ISO 9000 guidelines, ISO 27000 guidelines. So many guidelines are there. And then there's the ITU, which also plays a very important part in terms of what you can transmit from where, and that from where doesn't include only satellites; it also includes the ground segment also, and specific they allot specific frequencies to specific purposes in specific regions. So therefore, all this is really the kind of things which are there in different parts of the space usage. And all these guidelines, the main thing to understand is that these are expected standards and must be followed by the manufacturers and operators for the mitigation of space debris. Again, non-binding, that's the main issue. Now let's look at the guidelines of that interagency committee. Okay, so it says that it is recommended that a feasible space debris mitigation plan be established and documented for each program and project, which should include the following items. For example, a management plan addressing space debris mitigation activities. It should include that. A plan for the assessment and mitigation of risks related to space debris, including applicable standards. The measures minimizing the hazard related to malfunctions that have a potential for creating space debris. A plan for disposal of the spacecraft and or orbital stages at the end of mission. Justification of choice and selection when several possibilities exist, and compliance matrix addressing the recommendations of these guidelines. Again, these are suggestions, but these are very valuable suggestions, and one day perhaps these will become part of the law, the treaty. Now, countries must follow this standard. Now, to draw these guidelines, this IADC has used resources from all over the world, and you can see that it's from the United Nations, it's from the United States, it's from the European Union, it's from France. There are so many sources, which means an important point is that now countries are looking at these issues. It's not just the UN which has been looking at it, even individual countries are looking at it, and that's the way it should be, because the individual countries then should take responsibility and start action to reduce the cluttering up of space with useless things. And there is a further list I have put here. Those of you who are interested can kind of Google it and read it up. Now, this is important at how the thing progresses. So the IADC set up a set of guidelines. Then the United Nations Committee on Peaceful Use of Outer Space, they adopted these guidelines but made some simplifications in that and some modifications, because all countries have to. And here is again another important point, that the United Nations Committee on Peaceful Use of Outer Space works on the principle of consensus, not voting. So unless and until each and every member of the council agrees to a particular formulation, it's not adopted. So therefore, sometimes you need to modify things. And of course, I can tell you one thing, that sometimes the modification makes it so general, like the remote sensing principle, that nobody bothers to observe it. And that's an occupational hazard perhaps. But anyway, the point is they work on consensus. So the United Nations Committee on Peaceful Use of Outer Space, they adopted the IADC guidelines with some modifications and simplifications. Okay, and then this was first adopted by the subcommittee, the Science and Technology Subcommittee of the Committee on Peaceful Use of Outer Space. And you see the paragraph which I've taken from that particular report of the meeting. The committee noted with great satisfaction that the space debris mitigation guidelines have been adopted by the subcommittee at the 673rd meeting, and that's the reference document. And then item number 118. At its 572nd meeting, the committee endorsed the space debris mitigation guidelines, again given in the annex of that particular document. And and I've given you the reference, that the General Assembly official records 62nd session supplement number 20, and the document number is A/62/20. Okay, those of you who are interested can go and read it. You have to have some patience to read that. Okay, then there is a resolution of the United Nations. So what happens first? The IATC is adopted by the SNT subcommittee. SNT subcommittee gives it to the main committee, which is the United Nations Committee on Peaceful Use of Outer Space. They adopt it and then is put up to the General Assembly. And the 62nd session, agenda item 31, resolution adopted by the General Assembly. Point number 26, endorses the space debris mitigation of the Committee on the Peaceful Use of Outer Space. Point number 27, agrees that the voluntary guidelines for the mitigation of space debris reflects the existing practices as developed by a number of national and international organizations and in its member states to implement these guidelines through relevant national mechanisms. The key point is now the national mechanisms. So UN simply says, yes, this is good, I think you should follow this. Now you implement this in your own national mechanisms. Very important point to note. So what are the various legal hurdles now for debris removal? We've seen a lot of technology which Sivaraman talked about in the last lecture. What are the problems? The problems are, since the launching state has permanent ownership of the objects launched by it, only that state can remove. Go back to Outer Space Treaty which I discussed. The ownership of the object launched into space remains with the launching state. Okay. Now this acts as a deterrent to debris removal because the debris also belongs to that state. Now if the debris also belongs to that state, who will remove the debris? That state only. Because any second party, if they want to remove it, they have to have the permission of that first party, which is the launching state. And any mechanism used to capture and deorbit debris or destroy debris can also be used aggressively against another state's space asset. This is again a huge important point, right? Because I think in the last lecture, Sivaraman talked about very powerful laser. Okay, I can use a very powerful laser to vaporize some debris, but I can also use it to vaporize a spy satellite which I don't want to see what is happening in my country. So it's a double-edged sword. Then such mechanisms therefore could also fall under different restriction regimes like the US ITR regime, basically the regime which says that there are certain high-level technologies which cannot be exported from the US. So now, if suppose somebody who goes to the space and pulls down a US spy satellite, a lot of technologies are there which now become, even though the property belongs to the US, but you can always reverse engineering it and then send it back to the US, saying here is a satellite which I removed from space. Right? What can the US do? So there is this kind of reverse engineering IPR related problems also which can happen in debris removal, and therefore this raises a lot of legal hurdles. So there are many other issues, like for example, there has to be an agreement between the state owning the space asset being deorbited and the state agency doing the actual deorbiting. I can cover this. This will also include technical license authorizations, right? Because suppose India is trying to deorbit a satellite, say launched by say Israel or something, and then there are issues relating to export because technically Israel is exporting that satellite, India is importing that satellite, so all those rules and regulations will follow. Then the state whose space asset is deorbited and the state doing the deorbiting are both liable if any damage occurs to any third party space or ground asset. So that's also an issue, because supposing in the example India has agreed with Israel and Israel is deorbiting an Indian satellite, and then suppose a third part of in the process of deorbiting that satellite goes and lands on, let's say, Sri Lanka. So now both Israel and India are liable for the damage caused in Sri Lanka. So apart from this, there is a cost. Who bears that cost? Okay, and therefore what will happen is that the insurance cost will go up. So every time now you launch a satellite, you have to pay higher insurance, because now there are several ways of looking at it. People are suggesting. One is you think of space debris as abandoned property, right? So somebody has launched a satellite, the satellite life is over, satellite is breaking up, it's all done, and like you have a non-working mobile phone and you throw it out, right? Because nobody will buy a non-working mobile phone anyway. So it is an abandoned property. So somebody else can pick it up and break it up and use the gold and whatnot. So the whole problem that is cleaning space debris is the issue of the ownership again. In the Outer Space Treaty, And then how do you establish the ownership of small parts, 10 centimeter size parts? And another thing can happen is that supposing somebody tries to remove that, some other state may say, "Hey, that's my satellite part that you're taking away," and then you create some sort of an international situation, creating a lot of halla gulla. So one possibility, therefore, is to avoid all this is to treat space debris as abandoned property and of no value, right? Negative value, in fact, right? So if you do that, then what happens is that now we look at ways in which can this part of the thing can be handled. So we have understood that it is difficult to assign space debris to specific states. So instead, what can be done is that the states should be required to pay for the disposal of debris in proportion to the amount they create, right? So if USSR has created the maximum amount of debris, the biggest share of debris removal cost should go to USSR. So in principle, a UN could create a fund, a debris removal fund or something like that, and then charge, get contributions from various countries, so Russia, USA, China, India, in proportion to the amount of debris that they have created, and create a fund and then use that fund for the cleanup. Okay, so states or companies incentivized to begin cleanup operations at their cost will be covered by the. So this is again an issue. So now, because one, you have treated the debris as abandoned property, so the legal issue is taken care of, the ownership issue is taken care of, and now what you do is you create a fund, and then anybody, private party, another government, they can say, okay, I'll charge you this much for removing this much of the debris, right? So it's like a fellow who comes to your house and takes away your, all your kachra. The same way, you can have a company which comes and takes away all the kachra from space for a fee. And then also such a fund could then be used to compensate other countries which have been affected by the space debris, coming and landing on their country, or hitting their aircraft or something like that. Okay, but these are ideas. These are still not even in the realm of discussion. It's just ideas are picked up from different literature. So there is an international congress on the space debris remediation, which was held, I think, in Europe, and then they formulated the following. They said there should be a cost-effective technique, a proper legal policy frame to protect the parties involved, and to deal with alternative use concerns. Again, remember that IPR issues, and available and willing targets for removal or customer for servicing. Then funding for establishing, testing, developing technologies and space debris removal techniques, and for carrying out such operations, accurate tracking and necessary assistance during the operations, capability to locate, approach, connect, deorbit, service device, control orientation, move the target object to desired location. These are all the possibilities which I think Shivaraman discussed in the last lecture. Safety of the public on the ground, at sea, traveling by air and in space, again covered in the Liability Convention. So what are the possible future steps which are there? One is that there are two expert teams. One is led by the Massachusetts Institute of Technology and the other is the European Space Agency, and they are planning to put together an independent process that evaluates the decisions that operators make when creating their constellations. Because it's another huge problem now. Very proud we launched 104 satellites. Okay, those 104 satellites are going around the Earth, and one day they are going to become space debris. And those 104 are not the only ones. What is that? SpaceX. They launched another 60, and they want to launch I don't know how many more to do global coverage of internet. So what's happening is the middle Earth, the MEO and the LEO, medium and lower orbits are getting filled up with hundreds and hundreds of satellites, which is now actually approaching a kind of Kessler Syndrome problem, right? So therefore, there has to be some way of maintaining the sustainability of space, okay? And they are now coming out with something called a space sustainability rating, which is meant to provide an extra layer of accountability to companies that send vehicles into space, okay? And the company, and what is hoped is once you do this, then the companies will start competing with each other to build sustainable space systems as part of their unique selling proposition, okay? That they will say that, look, we are going to create less debris than that other company. Okay, so therefore we should be given the contract. Now, things like that are likely to happen. So that by creating a space sustainability rating, looking at space in terms of sustainable development of space environment, one can hope that one can bring in a regime in which the debris will start reducing. So the UN now is talking of something called the long-term sustainability of space, right? And in 2016 June, the working group on LTS, which is a working group set up by the SNT subcommittee of the UN COPUOS, and they discussed and brought out 12 voluntary guidelines. And then these guidelines were endorsed by the working group. This included promoting sharing of information on space debris and investigating measures to manage the space debris and so forth. And the LTS working group plan to continue and discuss 16 additional guidelines, and with the hope of reaching consensus by 2018, which they have not yet reached, by the way. So 16 plus 12, 28 guidelines were talked of. Then the first set of guidelines were agreed to, as I said, in June 2016. In 2018, consensus was reached on a preamble and 9 additional guidelines. And the working group was unable to reach consensus on its final report on how to refer the preamble and guidelines to the General Assembly. Right, so we are still stuck there. And 21 of these guidelines have been accepted. Okay, and if you want to know which are the ones, there is a document which I have referred to, which you can look at. 7 are still under discussion. Remember, I talked about the consensus. So in these 7, if you look at the document, you will find that there are alternate formulations for that particular guideline. Now that has to be discussed, and people will have to come to a consensus as to which guideline will be adopted. And it may happen so that each guideline will be discussed, and then there will be suggestions of adding, subtracting, modifying the one guideline so that it meets the requirements of the other 2 guidelines, and thus will become a single guideline which will then be adopted. So this is the way the UN works. So there are these guidelines are grouped into 4 categories. There is a policy and regulatory framework for space activities. There is a one is on the safety of space operations, international cooperation, capacity building and awareness, and scientific and technical research and development. These are the 4 major headings under which the guidelines are written down. And the 21 accepted guidelines, as I said, are available in that particular document, which is listed here. And the 7 under discussion are in another document, which is also listed here. Those of you who are interested can download these documents. They are free to download from the UN site. We have reference to the UN site also, and you can then satisfy your thirst for knowledge as far as legal issues are concerned. So in the end, I would like to say that my interest in space debris arose out of the Indian ASAT program. I personally do not support it, and I have written an article in the Wire about it also. If you have interest, you can read what I had written. But then I realized that there is a lot to be learned about space debris, its causes, detection, mitigation, etc., etc. And then we were discussing this with Dr. Vats, who is heading the SERF unit, and then he suggested why not we do a webinar, and then Dr. Gautam, Dr. Sivaraman and Bhandari also got into the loop. We met a couple of times, designed a webinar, and today is the last lecture on that series. So I thank Dr. Vats and Dr. Sivaraman and Bhandari, because we had some very fruitful discussions, both face to face as well as on the email. In fact, got quite a few good points from them. So it was a learning experience for me as I went through the ocean of literature, mainly on the internet. And here are some of the things which I referred to. I'm not going to read them out. You can, because this is going to go up on the SERF website, you can always refer to it and see this. And there are many more. I mean, I've just put a few. But I think the important one is here. For all the UN documents which I've quoted, you can freely download them from this particular website. It's a very, very good website. And then, of course, there are all other documents which are available. All these documents are basically online. I mean, it's a fantastic resource as far as the internet is concerned. So that is about it. And I'm ready now